I am Yvonne. I'm principal at Kaffour Law Firm. I am a mediator, family law, and personal injury attorney. We are located in Dallas, Texas. On this channel, I educate and empower you to resolve your own legal issues. My goal is to save you time and money and help minimize conflict, stress, and anxiety while going through one of the most difficult times in your life. Now, this channel cannot and does not contain legal advice. The legal information is provided just for general informational and educational purposes. Before taking any advice based on the information you obtain from this channel, please consult a licensed attorney. We do not provide any legal advice. The reliance or use of any information on our channel is solely at your own risk. Now, the overall goal for attending mediation is to settle the dispute. And so the goal is to get the mediated settlement. The goal is to settle the agreement in writing, signed by the parties in a 1, 2, 3, or 4-page document. And this document is called the Mediated Settlement Agreement. In today's video, I will be discussing the requirements of a valid mediated settlement agreement. And I will be telling you the effects of the Mediated Settlement Agreement, also known as the MSA. Let's get into it. The Mediated Settlement Agreement is the golden ticket to saving you money, stress, and time. So typically, the mediator drafts this agreement. But if you have an attorney, or if you have attorneys in the case, they would assist the mediator in drafting. First, let's talk about the effect of mediated settlement agreements. How effective is this document? It is binding. Mediated settlement agreements are binding. They are binding agreements between the parties, so long as the requirements of the state that you're in this case, Texas Family Code, the requirements of the Texas Family Code, as long as those requirements are met, then the mediated settlement agreement. So let's talk about what these requirements are. Number 1, the agreement has to be signed by each party. Both parties are required to sign the agreement. Number 2, this is very important. The mediated settlement agreement has to provide in prominently displayed statements, bold-face typed, capital letter, bold, written, that the agreement is not subject to revocation. If that statement is not bold and underlined, the mediated settlement agreement is not valid. Number 3, the mediated settlement agreement must be signed by the party's attorney, if any. They must be signed by the party's attorney, if any, who is present at the time the agreement is signed. So if your attorney is at the mediation, they need to sign that mediated settlement agreement at the time the agreement is signed. So you know what you need for a valid mediated settlement agreement. Keep in mind, the court's not able to change it. With regards to property, unlike other settlement agreements, the court's not required to decide or determine whether or not the property agreement constitutes a just or right division of the marital estate. Whatever you decide, whatever you agree to, is what the judge is going to sign off on. You can't change your mind after the mediation. Now, with regards to children issues like custody, child support, possession, and access, the court is not allowed to substitute their definition of best interest. They cannot change what you've decided is in your children's best interest. So this means that you have to be certain that you agree to the terms of the mediated settlement agreement before you sign. The courts cannot substitute its own idea of best interest to overturn the mediated settlement agreement. The judge is not required to decide if the property division is fair. So be sure that you can live with what you've agreed to. If you have an attorney, it's likely you would have to go through discovery or initial disclosures before you attend mediation. So what does this mean? Before you attend mediation, if you have an attorney, they would go through a process called discovery, where parties exchange their documents. This process is important because if you don't have the documents exchanged, then you can't settle a case when you don't know what you're settling. Now, if you do not have an attorney, you may not go through the discovery process, but it's important for you to exchange documents before mediation. This will be helpful in resolving your issues when you get to mediation. Exchange documents before. you attend mediation. If you have not already done so, be sure to subscribe to my channel, turn on the bell notification so that you are notified when I post new videos.